Good afternoon and welcome to today's Regulatory Transparency Project webinar titled Assessing the Federal Data Privacy Landscape, a discussion of the American Privacy Rights Act. We're all glad that you're here. My name is Marie Blanchard and I am the Assistant Director of the Federalist Society's Regulatory Transparency Project. We're pleased to have with us a stellar panel of experts. Note, as always, the opinions expressed are those of the experts. In order to get right to the discussion, I'll keep their impressive introductions short, but please find more about our experts at fedsoc.org. So first, we're pleased to have with us our moderator, Ashley Baker. Ashley is the Director of Public Policy at the Committee for Justice. Ashley's focus includes areas in the Supreme Court, regulatory policy, antitrust, and judicial nominations. Ashley is the founder of the recently formed Alliance on Antitrust Coalition. She has testified before the U.S. Senate on the topic of antitrust law. We have our other panelist, Brandon Pugh. Brandon is the director and senior fellow of the R Street Institute's Cybersecurity and Emerging Threats team. Outside of R Street, Brandon serves in the U.S. Army Reserve as a national security law professor at Judge Advocate General's Legal Center in school after serving as a paratrooper and international law officer. And Brandon is a non-resident fellow with the Army Cyber Institute at the United States Military Academy at West Point and a member of the International Association of Privacy Professionals Research Advisory Board. Our other panelist, Sarah Collins, is the Director of Government Affairs at Public Knowledge. Sarah currently serves as an advisory board member for the Future of Privacy Forum, as well as board member of the DC Abortion Fund. She also worked as an investigations attorney in the enforcement unit at Federal Student Aid, as well as the Director of Legal Services for Veterans Education Success. Our other panelist, Jennifer Huddleston, is a senior fellow in technology policy at the Cato Institute. Jennifer's research focuses on the intersection of emerging technology and law, with a particular interest in the interactions between technology and the administrative state. Jennifer's work covers topics including antitrust, online content moderation, data privacy, and the benefits of technology and innovation. And finally, Stuart Baker is a counsel at Steptoe and Johnson from 2005 to 2009. He was the first Assistant Secretary for Policy at the Department of Homeland Security. Stuart Baker has been General Counsel of the National Security Agency and General Counsel of the Commission that investigated WMD intelligence failures prior to the Iraq War. And with that, I'll hand it off to our moderator, Ashley Baker. Ashley, over to you.
Thank you, Marie, and thank you to the Federal Society for hosting this webinar on assessing the federal data privacy landscape, a discussion on the American Privacy Rights Act. So as many of you here know, Congress has been trying to pass a federal privacy law for a long time, with a lot of discussion in the last Congress on the American Data Privacy and Protection Act, or the APRA. Many were surprised to see a compromise emerge between the two committee chairs with the American Privacy Rights Act discussion draft this year. So proponents of the bill claim that the need for a comprehensive data privacy and security law is more important now than ever, and that such a bill will solve the problem of having an unworkable patchwork of state privacy laws. Meanwhile, opponents of the APRA argue that the bill would hamper U.S. competitiveness, impact the ability of small businesses to find new customers, and would empower an out-of-control Federal Trade Commission. Clearly, there are some mixed thoughts around it overall in some of these provisions, which our four panelists are going to discuss today. After the discussion with our panelists, we'll open up the floor for audience Q&A. So if any of you have a question for audience Q&A, if you can go ahead and drop it in the Q&A function on Zoom anytime during this panel, and we'll get to it in the last like 10 minutes or so of the panel. But if it's easier for you, go ahead and send me your Q&A now. And with that, I'm now going to turn it over to Brandon Pugh, who is going to give a bit more background on the bill. And then he's going to discuss our first question, which concerns federal preemption, including the politics around it and how it is reflected in APRA. With that, Brandon, the floor is yours.
Awesome. Thanks, Ashley. Glad to be here. Love the host too. Been following a lot of their programs for many years, so it's good to be on. Just looking at some of the attendees, I see we have a wide range of expertise. Some people follow this stuff as closely as any of us. Some people may not be. So just the level set of what we have now and what we're here to talk about. Currently, not to get through too much of the history, we're approaching, soon to be potentially 20 states with state privacy laws. We also see sectoral privacy laws like HIPAA and GLBA around finance and healthcare. And then we have more niche efforts to protect individual privacy as well, maybe in the national security context. But we don't have is a federal law governing the collection, sale, use, security, and transfer of data, which means that the average American outside of those states has no degree of protection for their privacy outside of those areas I mentioned. And Ashley did a nice job laying it out. There's been numerous proposals and efforts over time, but largely they have failed for a wide variety of reasons. And I'm sure we'll actually get into some of them today because a lot of them are coming up yet again. So where are we at now? You've already heard it with APRA, the American Privacy Rights Act. This is it's interesting because Chair Rogers, obviously Republican chairwoman, and Senator Cantwell, so a Democrat chair on the Senate side, came together and formed a bipartisan discussion draft. In terms of what's there at a very high level, there is a private right of action, meaning essentially individuals can vindicate their rights and sue directly for potential violations. There's a section on preemption, so getting at the sense of like how state bills stand up if there is a federal law. There's a section on algorithms and impact assessments, which I think is fairly controversial. We probably have mixed opinions on. But at a high level, there's consumer rights. So as a consumer, you'll have the ability to dictate when your data is collected, how it's used. You can ask for it to be deleted. I know it's a very high level overview, but in terms of where we are now, there was a markup just today, actually. It did pass out of the subcommittee and is on its way to the full House committee. So still a long road ahead, and I think there's still going to be a lot of changes and a lot of room for compromise and negotiation. But I think it is at least it's progress. I didn't really get it. I don't know if you want me to go right into preemption or not, Ashley, but happy to. I know.
Sure. Yeah, if you could discuss the issues surrounding preemption right now, surrounding preemption and the patchwork of state laws, that would be great.
Yeah, so there's a lot of areas that there's some contention over, but if I had to say like a top three, preemption would definitely be in there. And truthfully, it's probably the area I am most concerned about. Well, historically, I should say, because the thought is if we're going to have a national privacy law and add to this, add more regulation and more, law, there has to be a strong reason for it. And obviously consumer privacy is key, but the other side of that is making sure we can reduce some of the burden on the existing patchwork of state laws, which have a lot of similarities, but there's notable differences. And a lot of the proposals we see now are starting to, even diverge even further. And that's really unworkable for small and medium-sized businesses, let alone businesses of any size. Yeah, so that's really where the rub comes. Like if you are a state law that has a law already and we pass a federal law, what happens? Is that going to override your state laws, or could state laws continue and maybe states can go further than the federal law? So as it stands now, there is fairly strong preemption, and I think some people may disagree with that assertion. But in the existing law, essentially, if you have a state privacy law covered by some of the substance of this law, it would be no longer. But there are a series of carve-outs that allow for states to continue more niche aspects of privacy, largely areas that are not covered by this proposal, like criminal law, civil law, laws around bank records, public records. That's not the scope and intent here. So those are carved out. There's a lot more nuance to it that we can go into, and maybe some of the alternatives, like broadening some of the language to make it even more crystal clear on what the intent is. But I do think the congressional intent language that was added this time is really displaying where the sponsors' intents are, which is to make this the one federal standard and not have this existing patchwork we have currently.
So kind of building off of, you mentioned burdens on small businesses specifically. How exactly, should small businesses be handled under any privacy legislation or this bill more generally? How exactly will they be able to comply with this?
Yeah, so I guess it depends really on the bill, because there are variations even among the state laws we have. But speaking to APRA, so the discussion draft we have currently, at a high level, something I really take to heart is there is a distinction between a Main Street business having to comply with this law and when they have really no sensitive data or low amounts of data versus, a company that has tons of sensitive data on Americans and is really operating with very little constraint. There's a huge difference there. So you don't want to see that small businesses without data having to comply with a very large, framework. So getting that nuance is really important. And I think like that's one of the, at least publicly, that's something the sponsors have tried to do. So essentially, if you're a small business, and the definition around that is threefold: looking at a number value, looking at a number of records or of data that you hold. Those are the two more prominent ones. And if you fall under that definition, you'd be exempted from being a covered entity. So there's some more nuance to that, but that's largely how this bill approaches it. And that is a broader carve out than what we saw last Congress with ADPPA. But I would say that is something definitely to be mindful of as this bill works forward, is to make sure we're getting the small business provisions right, because we wouldn't want to inadvertently see somebody that has limited resources already now having to put more into compliance. And, we saw that come up just today in the markup. Representative Obernolte proposed a few amendments around small businesses on ways that he thinks it can be even more crisp. And there seemed to be a willingness to entertain some of those, his as well as other people's comments in the hearing.
And one final topic for you, Brendan, since your background is so closely related to national security and cybersecurity, how exactly does APRA relate to security?
Yeah, and I guess I should have said, like, if any of the panelists like disagree with me, or I know I'm being general at time, jump in. I'm not offended at all, because I know some of these are fairly controversial. But on security, I mean, that's one of the main reasons I think this bill is needed. Right now, there's really no requirement to secure data that you are holding. So if you're a company and you're collecting super sensitive data on Americans, that's desired by adversaries. Most companies are doing a really good job here. Contrary to popular belief, I think a lot of companies lean into privacy and security, but not everyone. And a law like this, it would set forth a requirement to secure the data you are collecting. And it recognizes that not every business has to have the same degree of security, precautions. And there's variations depending on the type of data you would hold. But even outside of that, there are some broader provisions that would relate to security. So for instance, a consumer would be put on notice if their data is going to select countries. Right now your data can be sold to China and you don't have to be notified of that. Like you may think that's something you'd want to know, but it's not a requirement. And I think, some of the other measures like data minimization would indirectly help security. By limiting the amount of data that's sensitive in the first place, it helps reduce maybe what's not needed for that company and what cannot be collected by an adversary in the back end. I say that all right. I say that meaning that we need data minimization has to be tailored, though. You don't want to see a scenario where we overly restrict what data can be collected in the back end limit innovation. So it is a hard balance to strike. And I know we can go into some of the more of the data minimization categories later if you want, but yeah, I'd say the overall point on security is it's not just a privacy bill. Like, yes, that's the intent, but there are both direct and indirect implications to security.
And turning things over to Jennifer. Jennifer, I know we were going to discuss AI and another number of other topics, but if you have anything to add to that, I'll give you the floor for a couple of minutes.
Great. Well, thank you so much to Federalist Society's Regulatory Transparency Project for hosting the event today, and thank you, Ashley, for moderating this panel. This has been a long-standing debate about what, if anything, should be done at a federal level when it comes to data privacy. But particularly over the last 5 years, a little bit more than that, since Europe's General Data Protection Rule, or GDPR, came into effect. And then shortly thereafter, we saw the first US state, California, passed what was then the California Consumer Privacy Act, or CCPA. And so you start to have both an emerging patchwork as well as potential concern about a Brussels effect and the impact that could be occurring for American companies and American consumers when it comes to the influence of this heavily regulatory European law on those products, because we saw in some cases that it was easier for companies, particularly when they were investing a lot of money in compliance with a law like GDPR, to simply roll out those features or eliminate those features globally as opposed to creating a European specific product. So now here we are in 2024, and there's still a lot of debate about what a federal data privacy standard should look like and if there's a need for a federal data privacy standard. One of the things that has changed in this debate is that we have a growing patchwork of state laws. It's now not just California. It's more than a dozen states that have their own state laws, as well as we've started to really see the impact of the implementation of GDPR. The US has had a great advantage in its light touch, harms-based approach to a lot of technology issues, including data privacy. So as we start to see this framework potentially emerge, the question should be, what are the concerns we're actually trying to address? And what are the areas that we can continue to preserve that light touch approach to innovation? In that regard, I think it's important to try and minimize the potential unintended consequences of data privacy legislation, whether it's on speech, innovation, or the availability and cost of existing products, both to consumers and to entrepreneurs, while also seeking to more narrowly and specifically address what the underlying harms might be. Ashley, as you alluded to, it wouldn't be a 2024 panel if we didn't talk about AI. So we can kind of start there and talk a bit about how AI is perhaps the latest unintended consequence that often gets caught up in the data privacy debate.
Sure, yes, if you could kind of expand on that and what exactly the impact will be on AI or AI-based technologies more generally of this bill or of any of the other proposals, that would be great.
As I mentioned a while ago, just a few minutes ago, in some cases, we have an example of what could happen when we look at what's happened with GDPR in Europe. Now, while APRA is not just a GDPR copycat, GDPR can be an example of how a more regulatory approach to data privacy can impact things like AI. So we initially saw that some AI products were unable to launch in certain parts of Europe or were held up by these various data protection agencies, not because there were concerns about the underlying privacy risk in the product, but just because there were concerns about their ability to comply with specific elements of privacy legislation. One of the issues with doing something in a regulatory framework is that oftentimes innovation moves much faster than regulation can. This can be a huge benefit in allowing innovation to move forward and to offer consumers new products without having to go through additional bureaucratic red tape in some cases. But in other cases, it can be incredibly problematic as we can see things like privacy legislation be effectively weaponized to prevent a technology that has gone beyond what the legislation was originally designed to do. That being said, there are some specific elements that could impact AI when we're looking at the APRA, as well as when we're looking at some of the state level data privacy proposals as well. A lot of those have to do with algorithmic decision making or automated decisions, because that's going to be very critical for AI. I know Stuart later on is going to talk a little bit more about some of the elements in APRA around civil rights, but another element that we often see is that kind of data minimization or data deletion requirements or data collection requirements could potentially negatively impact the ability to have, for example, a more diverse data set, or to ensure that your data set is representative in AI. So I think we have to now think about AI when we're thinking about data privacy laws and really ask, does this potentially have a negative impact on potentially beneficial developments of AI? AI is much more than just ChatGPT. And when you think about some of the things that AI is being used for in the medical context, and particularly the ability to personalize medicine, that may require a great amount of data that would otherwise be considered sensitive, and that I don't think many of us want to get in the way of allowing those huge scientific advances to potentially go forward.
So, Jennifer, another question I have is related. A lot of the talk around the federal privacy bill too has been around the Children's Online Privacy Act, which was also scheduled for markup today, and has kind of been hugging a lot more airtime in terms of debates when it comes to federal privacy legislation. Can you kind of piece together how exactly this relates to that and children's privacy more generally?
As you mentioned, we also saw the Kids Online Safety Act as part of the markup with APRA here today. There's an ongoing debate about whether kids' online safety or kids' privacy should be handled separately from a general data privacy framework, but there are particular elements within a lot of the broader data privacy bills that seem targeted at addressing young people. One of the issues here is that they often come with trade-offs that we may not realize could actually make it more difficult for young people online. whether it's making an experience less kid-friendly because you can't necessarily engage in targeting to keep some of the more harmful content out, or whether it's preventing kids from continuing to play a educational game because you stop allowing kind of continue on to the next level as an option because a game uses data on that individual student or that individual student's performance. So it's important to recognize that oftentimes general data privacy bills are going to have specific elements that are targeting young people that may actually make it more difficult for young people to have some of the benefits of connected activities or of data usage that makes for a more beneficial experience. The other trade-off there is when we look at a lot of youth online safety bills that claim to be about young people's privacy, oftentimes they could diminish overall privacy online by requiring things like age verification or requiring additional collection of certain data. These in order to engage in compliance with youth online safety requirements, these can diminish not only the privacy of the very young people that they claim to want to protect, but also the privacy of adult users, as the only way to know that a user is not under a certain age in many cases is to confirm that everyone is also over that certain age, which then of course also raises concerns around anonymous speech.
Okay, so Sarah, we're gonna move on to Sarah here, and I'll allow you a minute or two to follow up on anything or add anything to this discussion that you'd like before we move on to questions.
Sure. Yeah. No, thank you all for having me. I really appreciate it. I hope I can give a slightly different perspective than the ones that Brandon and Jennifer gave beforehand. I will just say to preview my remarks, organizations like myself and others in the civil rights community and the civil society community are very much looking forward to a privacy law in the US that explicitly protects civil rights and has quite a lot of like a regulatory robustness around algorithmic decision making and auditing of algorithms. We think that's incredibly important given the long history and the academic research that goes into discrimination by algorithm. And we think this is a totally incredibly necessary update to the current state of the law to make sure that we don't just shift discrimination that is happening onto machines where it can be black boxed and not be transparent at all, and much more and even more difficult to deal with than it already is. But yeah, one of the things that I think our organization is really excited about when we looked at both ADPPA, but also APRA, was a clear commitment to thinking about civil rights and how privacy harms can unfairly or more significantly impact marginalized communities and how their data may be weaponized against them. So that's just something that's really important for an organization like myself to be seeing, and hopefully that Congress will continue to recognize it's a necessary a harm to address.
So that leads perfectly to my first question, which is just why exactly does APRA, which is a data privacy and security bill, include civil rights protections, and why, from your perspective, are those beneficial to consumers?
Yeah, so I think it comes from a sort of thinking about privacy rights as human rights or privacy rights as civil rights. Privacy rights enabling us to more easily participate in society, and in order to effectuate that, as we have done before, to make sure that it is accessible, that it is not unfairly discriminating you based on, and this is included in APRA, things like race, religion, ethnicity, political beliefs, class. And that is just, I think, such a important foundation, especially for the Democrats on both the committees in the Senate and the House.
So a lot of the debate around this bill and around a lot of the previous privacy proposals have been centered around the private right of action.
Mm-hmm.
So what are the benefits of having a private right of action in APRA or any privacy bill for that matter?
Yeah, Brandon talked quite a bit about preemption before, and I think for our organizations both on the right and the left, it's been a tough road to get here, right? Just to be quite clear about perspectives, our perspective, if we could hand wave and create a magical privacy law that exists, would have a fairly robust private right of action and little to no preemption at all. We think it's important for states to be laboratories of democracy, but we have to work together to come to a compromise here. And part of that compromise for us is including a private right of action. And a private right of action narrowly tailored supplements and helps with both FTC and state AG enforcement. These enforcers have limited capacity, even more so at the states where the federal government doesn't control their budget at all and political priorities. So in order to make sure that cases aren't falling through the cracks, as we have seen in civil rights cases, but in other areas of law as well, having people able to bring their own actions for especially egregious cases of harms is really important for vindicating those consumer rights.
And one final question for you, Sarah, which is, so there's fairly large FCC preemption language in APRA that's fairly broad. Does that need to be addressed?
Yeah, most definitely. So it's sort of a two-part problem. The APRA has a very large FCC preemption that says that any FCC regulation that touches on the collection, transfer, or storage of data, as you can imagine, a Federal Communications Commission regulates quite extensively the collection and storage and transfer of personal data. That's what communications are. And a lot of that has very little to do with what we considered consumer privacy concerns. Robocall protocols of how we route calls, number interoperability is another one, 911 workings. All of these require telephone operators and others to process data in a particular way, in a particular fashion for the system to work. So on just a technical level, and I believe Representative Pallone brought this up at the subcommittee meeting today, this needs to be addressed. Now, as the next step, in which I'm sure some of my colleagues on this panel will disagree with me, I think our communication systems handles incredibly sensitive information, and we've always treated our telephone systems in particular as different, as requiring more confidentiality and a higher level of responsibility. Removing the FCC's expertise in this matter, and also not watching, which is probably some of the most sensitive avenues with which we transfer our data and holding them to a higher standard, we think is a real missed opportunity here.
Thank you, Sarah. So now we'll move on to Stuart. Stuart, I will allow you also, as with all of our panelists, a few minutes for rebuttal or to give a general overview of the bill before we jump into questions.
Okay, no, Sarah and I do disagree on this stuff, but she is right that one of the problems with artificial intelligence is it can be a black box, and you have no idea how it is arriving at the recommendations that it's arriving at. You have to trust that the training was done properly and that it is producing results that are going to make your business or the other uses that you have for the algorithm perform better. But you can't always tell exactly how it arrives at those conclusions. There has been, unfortunately, in this area, there's been a lot of bad research, I would say, claiming to find bias when what is really been found is a difference between how particular groups come out when an algorithm is processed. But of course, we know that that happens in real life all the time, that practically every rule of decision that people have has an impact on various demographic groups. And we don't automatically assume that that's discriminatory in intent. The problem here is that in an effort to regulate the presumed bias out of artificial intelligence, I fear that regulators and to some extent legislators are going to introduce much more serious forms of bias. And that was true for the discussion draft that was superseded just 2 days ago. It had a provision in Section 13 that took disparate impact as the central form of discrimination. And those who have been involved in employment discrimination law know that disparate impact really means if you do not have roughly proportional representation of every protected group, then you're presumed to have engaged in discrimination. And you can defend it, but it's hard to win those defenses. What the original Section 13 of this bill did is it said essentially, if you have disparate impact, that's it. You're discriminatory. You've got to fix that. And there's only one way to fix a disproportionate impact on particular groups, and that's to give those groups additional consideration until you have roughly balancing numbers. That's to say you have to have a quota program for anybody who does not get the benefit of your decision-making on the merits. And the idea that we would slide a quota program into a privacy bill and make it much more regulatory than even existing civil rights law is, was, I thought, pretty shocking, and I wrote about that. And the good news is that's gone mostly from the most recent discussion draft. There are still problems in the discussion draft. They still say we don't want discrimination or other forms of harm, and they're on a group basis as well as an individual basis. And so there is probably room for regulators or for the people who are coming up with compliance standards to say, well, if you've got a disparate impact, we're going to assume that you're causing harm to a group, because that's what it looks like to us, and you're going to have to fix it. And the only way to fix it is to impose quotas on your machine. My concern about that, in addition to not being enthusiastic about quotas, is that it will, because it's a black box, the people who are on the receiving end of losing jobs and losing promotions and losing opportunities to go to college because they don't fall into a protected group won't even know that it happened to them, because they'll be told, well, we have this bias-free box. It's been certified bias-free, and we ran you through the box and you didn't make it. And only if they actually are able to find out exactly how the box was trained will they know whether race or gender was introduced into the training in a way that disadvantaged them. And so to my mind, the remaining problem here is, how do we make sure that we don't introduce a lot of bias that will affect a lot of people and not even tell them that they're at risk, that they might have an ability to sue over it, as we saw with Harvard. All of that is going to be buried in the training of the algorithm, unless we're pretty careful about ensuring transparency about that kind of a quotified training of the artificial intelligence.
Sure, I believe you've kind of answered the two questions I had for you, but I'll kind of repeat the last one just in case there's anything to add, which is so does the latest discussion draft that was discussed today, does that fully resolve your questions, and like what more is needed? And you also kind of referenced the black box and how it's ultimately up to how exactly data is trained. What, if anything, do you propose we do about the issue?
So I'll be quick on that. I think it was the Chief Justice who said the way to stop counting by race is to stop counting by race. I think there probably should be, if there's going to be a discussion of algorithmic bias here, there probably ought to be something that says, whatever you do, don't introduce race and gender into your training in order to create some artificial advantage for particular protected groups. And you need to tell us what you're doing there, and it should be viewed as discriminatory to say, I took a model, and when I didn't like the results, I punished it for not treating a particular protected group better. And I punished it consistently until it started treating that group better without regard to the merits of the decision that was being made. And so that would be my suggestions, something that says we're just not going to be in the business of directly introducing race and gender and disability into the training of these machines.
Yeah, Ashley, do you mind if I say something real quick on that?
Sure, jump in.
Yeah, no, I think every panelist has kind of teed this up a little bit. It's really the nexus between AI and privacy of like how much should we be connecting the two in any legislative or regulatory efforts? And I'd say over the past year, it's actually been worse than it is now to really have at peak. There was an effort to like have a combined privacy and AI bill. I'm like, that'd be really bad. My personal preference is really to like have a privacy specific bill with little, if anything, on artificial intelligence. Like the way I see it is, I think privacy is the foundation for AI. AI is about data, and a lot of these concerns go much broader than artificial intelligence. They're applicable even outside of that technology. So I think I personally urge people to resist the temptation to try to put too much into one bill. It's gonna be hard enough to get compromise around a privacy bill, let alone when we start adding even more and more around AI. But what Stuart's getting to is really around the impact assessment piece. Essentially, if you're a company engaging in algorithms, when you have to assess it, and then who gets that assessment? As it stands now, you could either use a third-party auditor and you hire them, then the report goes to you, or the other option is you do a report and it goes to the NTIA, and it's not crystal clear on what the NTIA does with that report. So that's one thought. Then always the ongoing thought I think for industry is it going to be used against us for enforcement purposes? Like if we give this report up, is somebody now going to come sue us with it? I think a lot of those, a lot of those questions have kind of been, considered. They were raised today in the markup as well. So I think that'll be a piece that really make sure we're getting right. Because I agree with all the panelists. Like we don't want to see innovation in AI slow down because of bureaucracy, but there are legitimate privacy, considerations too.
So if I can jump in here, I'm going to somewhat agree with Brandon in that I do think it's important that we recognize what exactly the tech policy issue a particular piece of legislation is actually trying to address. I think often one of the underlying questions is, what is the harm you are actually trying to solve in these debates? Now, I will also point out that in polling repeatedly, concerns about data privacy have been shown to be the top concern of Americans when it comes to what are you concerned about in the tech space. I believe there's been yet another poll kind of showing something similar, sometimes slightly more nuanced to certain types of privacy. But if we're going to talk about data privacy, we do have to think about kind of these trade-offs that could happen. So while I don't think we should see data privacy legislation as AI legislation, I do think it's important for us to recognize the way we restrict or allow the use of data could impact the development of AI. On the other side of that, I think there is a potential for data privacy regulation, if done correctly, to perhaps alleviate some of the concerns that some individuals may have around AI. Oftentimes, what we actually are hearing, whether it's AI concerns or it's kids online or it's concerns about social media, when you dig down into it, the actual concern is about someone feeling like they're not in control of their data or that they don't understand what's going on or they don't understand what their rights are if something goes wrong. So where we can provide consumers clarity where they can then make the informed choices that go with their actual privacy preferences, not even just something that they say on a survey, I do think that in that way, a data privacy framework could be beneficial to AI and into alleviating perhaps some of the fears people have about how their data may be used in that process.
And you point out actual privacy preferences versus something they say in a survey. Do you mind adding some clarity to that?
Sure. So privacy is a space where we often see a huge discrepancy between stated preference and revealed preference. Typically, people will say that they're in favor of strong privacy restrictions, that they want to have a lot of control over their privacy. But then when you actually ask them to do some task or you create some friction in the process, then they don't have that same strong preference. So, for example, if you say, how much would you be willing to pay for a non-ad supported version or a version that did not use your data of a certain service, oftentimes the amount people are willing to pay versus the amount they say they value privacy may vary tremendously. Or if you clarify that a certain feature wouldn't be available, or if users even experience that a certain feature isn't available because of selected privacy preferences, being able to find nearby restaurants on a map, or have your Chick-fil-A order ready when you pull into the restaurant because you need the GPS location for that. You'll often find that people may act differently than they would state on a survey question when it comes to the choices that they make around data privacy.
And before we move on to questions from the audience, Sarah, is there anything you would like to add from your perspective?
Yeah, so I clearly disagree with Stuart about the sort of assessment here. One, I think we just fundamentally disagree about whether or not these harms are occurring. I think the cases that have been brought against Facebook for housing discrimination, the work that's been done in the medical space about how algorithms can exacerbate existing inequalities between Black patients and white patients, as well as how credit scoring happens between Black couples and white couples. That all exists, and it gets exacerbated by algorithms. So I believe the harm exists, and that may be a bit of a difference for us. But two, I think the idea that this somehow mandates quotas is a bad faith reading of this section. We've had a disparate impact as part of the law for quite a while now. I don't think, and we've said since the 90s that quotas are not legal. The way that you're supposed to deal with a discriminatory policy or practice is to not use said discriminatory policy or practice. It is not that you must have the exact correct number of men and women, of LGBTQ people, of certain races. That's not and hasn't been how we've sorted these problems, and I don't see why that would happen in this case. And then finally, while I understand the impulse to say that then there must be a removal of questions about let's say particularly sensitive classifications, religion, race, sex, even if that were to be useful here, which I could argue that that information might be useful in other contexts for non-discriminatory purposes. Furthermore, it's very easy to derive that data, especially from location data and other information about where you went to college, what kind of jobs you have, and other things, just based on how society has sorted itself. So all of this is to say that I vociferously defend the civil rights protections in this bill, and really would like to see very strong auditing provisions. It has changed since the first discussion draft. And where I think we do agree is I'd love to have far more transparency about the training sets and the data that's going into these algorithms.
Stuart, I'll give you right of last reply.
You would think if I could jump in for a second on the question of whether it's a bad faith reading. I think I just urge the audience to take a look at the article I wrote for the Wallet Conspiracy on this. The statute was, in fact, I suspect, an effort to sneak a whole bunch of stuff by the Congress. It has now failed, and we're not going to be debating that. But it included disparate impact as a harm, and didn't even include the defenses that people have in the employment area for disparate impact. But I think we can set that aside, other than for those of us who discovered it late, we're a little worried that it's being smuggled in a little more cleverly this time. And there are some provisions here that ought to be looked at carefully and probably require something that says, no, whatever you think that means, it does not mean you should artificially insert a bunch of considerations about race and sex and gender.
So thank you, Stuart. So we're going to move on to questions from our audience now. There are two questions. I'm going to kind of combine them into one. And seems like we have a lot of questions about federal preemption of state laws. First question, as someone who works on policy at the state level, I am interested in preemption. In your opinion, what will the preemption provisions of this bill look like in its final form were it to be enacted? And a somewhat similar question we had from another audience member, references the Illinois biometric privacy bill specifically, points out that it has had a lot of litigation regarding idiomatic cases. Will that be federalized, or will it be preempted?
Well, if you want, I can start us off.
Sure.
Yeah, I come from being a former ledge counsel for a state, so I definitely feel your pain. I'm a pro states' rights guy, which, contrary to wanting a federal law, you would think they're contradictory. But let me first caveat saying that, like, this bill is a long way from being done. Like, first off, like, being mindful it's an election year is, like, politically there's a roadmap here, but there's also an appetite to continue to make changes. So I think if people take anything away today, if you read this bill and you think there's an issue, I would encourage you to raise those. Maybe not everyone will be acted on, but now's your time to engage. And I say that because preemption, it's hard to say exactly how it'll play out. I would say there's a lot of similarities between the current language from prior iterations, where there's been a large degree of support. Essentially, having strong preemption with a series of states carve-outs. And the exact carve-outs may vary, but the thought is, let's allow states to continue to act in areas they have traditional state authority and in areas that are not implicated by this bill. We wouldn't want to see a scenario where it's 100% preemption that overrides everything that's privacy related, even if it's not covered by this bill. But I'd say there's some nuance on each side. You have some states like California that are saying, well, okay, we'll go with the federal law, but just allow us to go stronger than the federal law. But is that really, how much value is there in that degree of preemption? That would be my argument against. The flip side is, can we tighten up what we have now? Go after some of the language and perhaps make it even more crystal clear that the intent is not to allow these standalone state laws like California, Connecticut, just to name a few, and maybe do away with some of the carve-outs. So that's to be determined, I would say. But I think just personally where it's at now is where there's probably a fair amount of support, but maybe some efforts to tighten it just to make it explicitly clear that, as a trade-off for having a federal law, we don't want to now see 30 individual varying state laws still on the books.
Thank you. Anyone else have anything to add regarding preemption?
I think it's important to recognize that if we don't see a preemption and we continue to see the patchwork, what that means for not only businesses, but also what it means for consumers. We've seen this around other issues, including data breach, where we do have a 50-state patchwork, that there's a lot of confusion amongst consumers about what is covered and what's not. We're doing this via Zoom. I can be, and particularly for those of us that live in the DC area, I can be sitting in Northern Virginia, someone else can be in Maryland, and someone else can be in DC. And in a world without a federal standard, we're covered by 3 different privacy standards and 3 different data breach laws. That being said, if the federal standard is a floor rather than a ceiling, that's going to be particularly difficult to deal with for smaller businesses and for consumers, as what you might see is an increasing amount of costly litigation, as was mentioned in reference to the Illinois bill, particularly if you have statutory damages. But also for smaller businesses, that's going to mean a lot of trade-offs in determining what states you may or may not be able to offer your product in, because you may find yourself complying with the federal standard, but then if there are significant additional requirements to, say, operate in California or to operate in New York, you may find that you're not able to offer the same service there, or that you have to make so many changes to your service that you end up with without solving the problem with actually another de facto federal law coming from California, for example.
Yeah, that's a good point Jennifer makes, and just to really drive it home, that's one of the concerns around the preemption language is if the victory is to have strong preemption, you wouldn't want to see and not implying the person that asked this question, but you wouldn't want to see a very ambitious state now look for loopholes. Maybe you're using a carve out to actually still regulate privacy by saying, oh, well, it's not a comprehensive law, but it's this type of carve out. You want to avoid that. That's the reason, like, it seems very straightforward, but it is extremely nuanced to get right. Or we're really that much better. I don't want to see a scenario where we have 51 privacy laws, or even more if we had some of our territories. Yes, that would help consumers for sure, and security perhaps, but still be a huge, barrier for industry.
Thank you. So moving on to our next question, which points out that the discussion draft treated third-party browsing data as quote-unquote sensitive information that could not be used for targeted advertising. Wouldn't that undermine the fundamental economic model that finances internet content? And wouldn't it create enormous competitive advantages for the large platforms that rely on their own data?
Yeah, I'd love to take that. So, one, it would change the economic model. I think right now you have such hyper-targeted advertising because everyone can do it, right? If you're offering as a service for your website, contextual only, you have to charge much less, and you're not owning your audience, right? You're getting eaten by Google and others who are saying, I can find their audience for you. Don't worry, I don't need to have you here. While the concern about the big players, it favoring them because they have a lot of first party data, I think two things undercut that substantially. First is that quite a lot of their data is created when they're acting as these third party agents. Google as its ad tech platform is a really good example of that, or Google as Pixel, or the Facebook thumbs up button, all of which are plugins on other first party websites where they can collect data about you. But also, this is not the only restriction on sensitive data. So while other platforms may be able to collect a lot of information about you, much of it may be sensitive and therefore not available for this sort of targeted advertising. This is, to be quite frank, on my end, this is trying to push a shift in a targeted advertising model, because what we have seen, or what we have been seeing, is sort of a race to the bottom, to the most targeted, the most invasive, the most data collective. And the way to deal with this is to make sure that no one can engage in this, so that less invasive forms of advertising can rise to the top.
Yeah, I don't know if Stuart or Jennifer have anything on that, but I don't want to talk too much if they do. Yeah, no, yeah, what I would just say to that, I think this is one area where we see probably the most changes, especially not only from the previous draft last Congress to our initial discussion draft to what we had just days are getting mixing together, like 48 hours ago. That we've seen a lot of changes. I think the takeaway is really making sure that we, at least from my perspective, there is value to ads. I think they can be misused occasionally. We've seen some bad actors do that, but ads have very valid purposes. And I think that's the key, is anything we do and any future changes to ads, I don't want to see the entire ad ecosystem demolished or done away with, but is there room to have, some more common sense approaches to them? And, one area that, we see this is, to give some concreteness to this, there was a lot of confusion on the first draft. Was, in one hand, it said you could do targeted ads, except if it was sensitive cover data. But then if you read the definition of sensitive cover data, it was essentially data over time across websites. And that's like, well, isn't that a lot of ad data? So can we or can we not? So I think that's really the takeaway, is having clarity and then making sure we're balancing legitimate uses and the reliance on ads by small businesses and frankly consumers versus some of the more nefarious, unfortunate abuses we've seen in the past by some less than stellar actors, which is, I think, a minority of the industry, but maybe some would disagree.
Brittany, could you go a little bit into how sensitive data is specifically defined in the current version of the bill?
Yeah, gee, I guess I should have had the actual text pulled up in front of me. So yeah, somebody else has it pulled up. Feel free while I pull it up that way.
And so the hardest part about any of these privacy bills is getting through the definitions. What exactly is and isn't a covered entity, and what type of data is sensitive or not sensitive, and how exactly expansive those definitions turn out to be is really where the rubber meets the road half the time.
Yeah, and it's key, because if you read this, like how regular cover data is treated in different sections versus sensitive data, certain times sections will have both usages. So it's really key to make sure you get it right. And obviously, it goes without saying, there's a lot more restrictions on sensitive data than there is just normal cover data. And yeah, this has been a source of contention, I'd say, on what goes into the sensitive data definition, and it's not consistent. So for instance, if you saw some of the recent action coming out of the House, as well as a recent White House executive order, their definitions of sensitive data is different than the definition we see here. But even if you pull it up, and there's a lot of examples, so I do challenge people to look at it if you're interested. If you're like me and you actually love the text, it's on page 30. That's everything from government identifiers to biometrics to geolocation data. Some more unencrypted data would fall into that. But there are some concerns, I would say, that maybe is there a scenario where we cover too much, and we're considering something sensitive, and that would have a downstream impact and maybe limit a valid use of sensitive data. I think particularly that comes up sometimes in the AI space.
Well, and I think it can also come up in the targeted advertising space when you consider something like geolocation, for example. Many of us can imagine that there are times where you may not want to share your geolocation with an app or with a certain service, either because of personal preference or because of actual security risks that you may feel. But I think a lot of times we don't necessarily fully think that through. So earlier I gave the kind of example of maybe I don't know why Chick-fil-A or Starbucks wants my geolocation on their app until the first time I try and show up and my coffee isn't ready and I'm sleep deprived and I'm wondering why it's not ready. And it's, well, we didn't know you were on your way and you didn't click 3 more buttons or whatever. Whereas if I'd shared my geolocation, I could. But from the targeted advertising perspective, when we think about geolocation, I think we should think about small businesses that may be engaged in advertising. The ability to do targeted advertising and to do online advertising has generally lowered the cost for small businesses to advertise and really benefited a lot of those small businesses in being able to reach consumers that they might not have otherwise been able to reach. You may, however, though, maybe you're a local bakery and you don't ship your baked goods, only want to target people within a certain city or within a certain geographic radius, and that may require geolocation data. So even when we consider data perhaps in general, that there may be scenarios where we as individuals consider it sensitive, we also have to think, again, it's all about those trade-offs, and we really have to consider what that means. And I also think we have to be careful not to necessarily make malicious what are often benign and even beneficial practices. There are certainly bad actors out there when it comes to target advertising or when it comes to abusing data, but there are a lot of cases where this has actually made our experience much more tailored and much more enjoyable online in ways that we would really miss if it went away. And so I think that we have to be careful not to presume that what is often a practice that consumers enjoy is automatically going to be something that or is presumed in law to be harmful just because of how a bad actor could abuse that process.
So I think that's probably about all that we have time for today. I want to thank all of our panelists for coming out today and all of our attendees, as well as the Federal Society for hosting this panel. And with that, I think that's it.
Thank you to these fantastic panelists for sharing their points of view, and thanks to you, the audience, for tuning into this program. For more content like this on the regulatory state and the American way of life, please visit us at regproject.org. That is regproject.org.